In medicine, sometimes things go wrong. Thankfully, not often, but when something does go wrong, we do have an ethical and moral obligation to reflect on what happened and try and improve our own practice and also the systems around us to make the same thing less likely to happen again in the future. But when we're sitting with our colleagues discussing an adverse outcome, are we free to openly discuss what went wrong and what could have been done differently? Are we looking over our shoulder, wondering whether what we say may be used against us if we brainstorm alternative approaches, even if those approaches weren't actually appropriate at the time? Often in those conversations, there's a lot of speculation and just thinking around the issue. But can that be a risk to us? I think we may all be a bit wary of openly discussing our mistakes if we think our openness and speculative thoughts and candour may come back to bite us later, if the matter is taken to the HDC or the Medical Council. So, welcome to Reducing Risk. This is a series of podcasts from Medical Protection created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medical legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. And today we're talking about when we as clinicians gather to talk about adverse events or adverse outcomes, such as morbidity and mortality meetings, and how much we can say and how open we should be in those forums. And today I'm joined by my colleagues Tim Cookson, who's a medical legal consultant with MPS. Hi, Tim.
Hi, Lucy.
And Dr. Sam King, a GP and also another MPS medical legal consultant. Hi, Sam.
Hey, Lucy.
And Adam Holloway, a partner at Wood & Kearney, our panel law firm. Hi, Adam.
Hello, Lucy.
So I just want to illustrate this issue by talking about a case that recently came to my attention. A doctor contacted MPS because she had been asked if she'd be happy for the minutes of a morbidity and mortality meeting to be shared with the HDC. The manager who was suggesting this had very good intentions. They wanted to show the HDC that the matter had been thoroughly reviewed, that the hospital had learnt some lessons and would be improving their systems for the future. And that's all good, isn't it, Tim? What do you think about the hospital approach here?
Well, it would be good if that's all that was going to go to the HDC was, that they'd learnt some lessons and would be improving their systems in the future. But as you've hinted, there's often a lot of other discussion that goes on in a morbidity and mortality meeting. And if the person who's taking minutes has written detailed minutes of those discussions, there may be a lot of information that is either not directly relevant to the case itself. The case may sort of flow over onto other situations within the hospital, and it's used as an example, but there are other systems issues that might be much more relevant to other cases rather than that one. And in the end, may provide a very slanted view for the HDC, and given that the HDC is looking in general to find fault rather than to ignore fault, then they're likely to pick up on stuff that's there. And I guess my concern with the use of the morbidity mortality meeting to provide that information to the HDC that, yes, the hospital's taken note and is going to make some changes, is it's actually the wrong kind of document to be used, and that it really ought to be the Health Quality Safety Commission document with the Severity Assessment Code and the subsequent analysis that's been done. That is the right document to provide to the HDC that shows that, yes, this has been properly investigated according to the official processes, and yes, lessons have been learnt, and this is the program as to how those lessons are going to be enacted. So the mortality morbidity meeting minutes are the wrong information in my view.
Yeah, and I think that people who are documenting the minutes may or may not have captured what was important, what was not. And I guess I wonder how often it is that the clinicians even review those minutes, so they wouldn't know what is in them.
And particularly when something's gone wrong, most doctors, in my experience, actually are their own harshest critics, and they constantly believe that they should have done better when, in fact, they did a really good job in very difficult circumstances. But if you're doing the real sort of heart-to-heart mea culpa type thing in a discussion within a mortality meeting, and in some ways, what you're hoping for is some of your colleagues to say, actually, well, no, you were much better than what you were saying about yourself. But what the HDC might capture from that discussion is the doctor themselves thinks they did a really bad job. Well, that's interesting information. Let's pursue that a little further.
And when you know the end, the outcome, it's quite hard to approach a case without bias, don't you think? It's quite hard to say, well, given what I knew at the time, the information I had to hand, was this a reasonable decision? And often it wasn't the right decision at the time. But it's very hard to get away from hindsight bias, particularly when there's been a tragic outcome.
Mm-hmm. If only I'd known that such and such was going to happen, then I would have done such and such. Of course. And that's the only bit that comes out, is that I would have done such and such, and should have done such and such, yeah.
And sometimes in those meetings, you've got colleagues standing up, kind of blowing their own trumpet. I would have done that. And, oh, why did you do that? And in those situations, again, if that's minuted, that somebody else thinks an alternative approach would have been more appropriate, that's something, and it may not have been, but somebody stood up and said it, with all that hindsight bias. You can imagine that being something you don't necessarily want to share with the HDC.
And it's not uncommon for those meetings to be used as a venue for personal vendettas to be explored. So, yeah.
Yeah, so I think we can all agree that there are risks in sharing some meetings and some minutes with external authorities when that wasn't the reason for having that minute. As Tim says, there are perfectly legitimate inquiries where actually there is some balances and checks and balances in there, whereas often the discussions in these peer reviews or morbidity and mortality meetings isn't necessarily very balanced. So look, there are all sorts of reasons why those minutes may not be a fair evaluation of the case, and actually may in fact suggest issues that weren't even relevant or appropriate. And that's exactly what happened in this case that our caller was involved in. The clinician involved had never seen the minutes. Many issues had been raised that weren't the actual problem in that particular case. And the suggested changes in the systems weren't actually relevant to that specific case, wouldn't have prevented the adverse outcome. But if provided to an external forum, may have actually raised more concerns than actually truly should have been there. So what to do?
Well, the minutes are the minutes. I suppose the clinician, if having read the minutes for the first time just before they're about to be sent to the HDC, thought, well, actually, that's not a fair reflection of the meeting, then for most meetings there is a process to go back and have minutes changed, but that's probably going to be unlikely. So, those minutes are likely to be those minutes and unlikely to be altered.
Do you think it's possible to decline a request to send the minutes to the HDC? When the HDC send that letter out to all of us, they request certain documents. And so if they are asking for all relevant documents, minutes of meetings, etc., I think it would be quite hard to decline that. Do you think?
Yeah, and the other issue is, of course, if the HDC become aware that there was a morbidity and mortality meeting, they're likely to actually specifically request it as well. And so, and if they specifically request it, I don't know, Adam, what do you think? Are we allowed to say no to the HDC when they ask for the morbidity and mortality meeting minutes?
Well, unless it's a meeting that has some special protection, which I think we'll go on to discuss in a minute, the answer is no. So the HDC generally start by just asking for things, and that's usually sufficient, because what they're asking for is what you'd expect, which is clinical records made at the time the care was provided. But if they do choose to ask for something wider or get specific and say, we think this was discussed at your M&M meeting, we would like those notes. And if that's not a meeting that has special protection, were you to say no, then you'd probably end up getting an official notice from the HDC. And so the legislation which governs the Health and Disability Commissioner gives the Commissioner power to, by notice in writing, require any person to furnish such information, produce such documents or things in the possession or under control of that person as the Commissioner thinks will be relevant to their investigation. It's a very wide power. The way we interpret that is to say the Commission can't ask you to, or at least it would be very tricky, and we could challenge the Commissioner asking you to reproduce writing information that's just inside your head. That would be a fight. But if someone's made notes and the HDC knows they exist and they ask for them, then push comes to shove, they can.
The wording of those letters is often, has there been any formal inquiry or investigation into the case? In which case, if you've done the HQSC process, you could provide that and not tell them that there's also been a peripheral discussion around the...
I don't think it's being tricky or dishonest to take the position. If it was asked in that way, I would not regard an mortality and morbidity discussion to be a formal inquiry or investigation. That's not what those are, and it's not what they're for.
So if they're going to get the minutes anyway, I think we need to think about what can we do to not be in the position. And I think we've already talked about this whole minutes thing, but I think there was some provision for it, wasn't there, Lucy?
Yeah,
in legislation.
So basically the lawmakers did consider the need for clinicians to be able to discuss cases and keep those discussions confidential when they drafted the Health Practitioners Competence Assurance Act in 2003, which is pretty impressive that they actually thought about it, I think. That they obviously thought we need to have some protected situations where clinicians can openly discuss things.
Yeah, so the Act does contain a regime for getting special protection for what they call quality assurance activities, and classically that is an M&M meeting. I think it's possibly still common for doctors to just operate on the assumption that certain sorts of meetings, and perhaps M&M meetings are the archetypal example, are protected. But that's only true if this regime has been followed and complied with. And it's a pretty exacting sort of set of procedures. There's a series of provisions in the Health Practitioners Competence Assurance Act that set out what these are and the process you have to follow to attain that special protection and then hold on to it for the long term. And it starts by setting out what the purpose of the quality assurance regime is. It says that the purpose is to encourage effective quality assurance activities in relation to health services performed by health practitioners by protecting the confidentiality of information that becomes known solely as a result of such activities, and to protect documents brought into existence for the purposes of those activities, and then to give immunity from civil proceedings to people who engage in discussions around those activities, which is a fringe sort of protection, but it's a nice to have. The most important thing is it protects in a very powerful way whether this regime is in place for one of your quality assurance activities. It protects the documents that are created as part of that. And so if you're making comprehensive minutes in your M&M meeting, and your M&M meeting is a quality assurance activity that you've gone through the process for, if you get one of those notices from the HDC saying we would like the minutes, well, then you can say no. You can point to the regime and say you are just not allowed to look at this stuff. It is private.
But just to clarify, information that might have been used, so for example, the notes or scans or results or whatever, that might have been used for the purpose of, or part of the purpose of creating those additional documents, which were then going to the meeting, those original documents would still be obtainable. Is that correct?
Yeah, absolutely. So because you bring something to a quality assurance activity forum, like a protected M&M meeting, it doesn't then cast the net wider to make confidential the clinical records, or, if immediately after the event two consultants are trading unhappy emails between each other about what they should or shouldn't have done, and then bring those emails to the meeting to try and thrash out their disagreement. The emails that were created beforehand, they don't gain protection. It's just the documents that are created for the purposes of that activity.
So you mentioned before, Adam, about all these sorts of hoops that you need to go through in order to become protected. What sort of hoops are you talking about?
Yeah, so there's a process, and there is some good guidance available from the Te Whatu Ora Health New Zealand website. There's a web page and also a PDF document that steps you through what you have to do. But in essence, you need to complete a form that goes to the Ministry of Health. You need a sponsor for that application, and the application has to nominate a person who's going to be responsible for the quality assurance activity. When you're completing that form, you'll be prompted to address certain issues. So, what are you going to call your quality assurance activity? What is its purpose? Who are the participants going to be? What's the methodology that you will follow carrying out the activity? What actions will be taken if your activity identifies a problem or deficiency, etc. So it's not rocket science making an application. There's good guidance and it's a pretty clear sort of form, but you have to make the application. And it has to be granted. And I think, again, there's sometimes an assumption that one of these is in place when it might not be, or an assumption that something that was in place is still valid. And there are ways in which these things can expire, and in all likelihood do expire without people really becoming aware of it. So we can probably come to some of those reasons, but well-run M&M meeting that you're wanting to remain a protected quality assurance activity, should run on an annual basis, where at the beginning of the year, the first agenda item is, has the right person submitted the reports that are necessary to keep this in place for the coming year?
Yeah, and obviously we've talked a lot about M&M meetings, but you can actually have audits protected and other things protected as long as it's a quality assurance activity. It isn't just meetings. So you have got to think about what is a quality activity, something that's going to improve patient care, but may highlight deficiencies that you don't particularly want to share with anybody, but you want to address and improve. That's the whole point of it, is that you want to allow health organisations and individuals to actually go looking for problems and address them without thinking, if I go looking for problems and find them, someone's going to criticise me. I think so it isn't just M&M meetings. But I understand that obviously there has to be a sponsor for the protected quality activity, but there also needs to be this responsible person for the activity. And that needs to be a named real person who is independent of the health practitioners whose services are being assessed or evaluated. So it can't be head of department. It can't be one of the clinicians who's actually involved, being that responsible person who has to do all the forms.
So that then gets a bit tricky in a hospital setting, doesn't it? So who's actually going to do it? And you can imagine that task would fall upon someone who's got a bureaucratic role and may not have as their number one priority keeping up all of the requirements of the protected activity. And they also may change relatively frequently, which may also create problems.
Yeah, because it's got to be a named person. So it's not a role. You can't say it's the head of quality and risk. It's actually got to be Mary Ford or Mary Smith or Alex, whoever. You've got to have a name, and it actually has to be somebody that is then responsible for making sure that documentation happens.
Yeah, and it's not an insignificant annual task, there has to be, and this is perhaps what puts hospitals off, particularly in an environment where we're not wanting to put money towards non-frontline staff, as the powers that be say. You need this responsible person to provide a report every year to the minister, and that has to outline any problems or issues concerning the operations of the provider, say the hospital, that have been identified in the course of the activity, outline actions that have been taken to resolve those problems, outline recommendations that are being made, state the manner in which the recommendations have been implemented or being monitored, and the manner in which improvements in the competence or practice of the provider are to be monitored. So a whole suite of arrangements. Now, sure, you can do a shortish form of that report, but at the end of the day, someone's putting their name to it, so it needs to be done properly and probably by someone who has enough of that interface of both bureaucratic and clinical knowledge or experience to know what they're writing, And so I think having people available within the organisation who are both around for the long term and capable of taking on that responsibility may well be an issue.
I think, though, if you can find that person, it's well worth it, isn't it, to have an open discussion where you can take learnings, know that it is protected. It just allows safety for the clinicians, to be honest and open. And I think there's always going to be value in that.
Yes, that's just, in the course of the discussion, thinking about it, it is only the changes that have been made as a result of that protected activity, isn't it? And you assume that a lot of the other stuff that's happening within the hospital, changes are going to be made that will improve services, et cetera, so there's a broad overlap, it would seem to me, between what it might come out of this protected activity versus other activities within the hospital that are not part of a protected activity. And that would create another problem for the person who's writing the report, which is which, what do we put in, what don't we need to put in? And I guess if you've got someone who's not clinical, as Adam has hinted at, could, ideally you want someone who's got both clinical and bureaucratic type experience or roles, because if the person who's doing the reports doesn't actually benefit from having that protected activity available, then that decreases their incentive to do a good job and make sure that it happens on a yearly basis and all of the provisions are adhered to.
Yeah, but clearly it is the clinicians who benefit from the protection rather than the manager who's writing the report. But actually, I think that the people who really benefit from the system are the patients, because actually, if you have a safe environment to discuss issues and adverse events, it's actually likely to make clinicians more likely to reflect on their approach and more likely to be open, and everyone's more likely to learn. And the people who benefit from that are the patients.
And that's certainly been well shown, hasn't it?
Yeah.
That if there are fora available that enable people to be completely open, then you're much more likely to get decent change. Yeah.
Mm.
So if you don't have a protected quality assurance meeting, then is it better to not keep minutes?
Yeah, and I've definitely heard people say that. Let's just not keep. Our peer group, we just don't keep minutes, or we won't put anything down on paper, and then that's a way of keeping it confidential. But obviously the problem with that is that actually the whole point of quality assurance activities is to improve long-term care, and generally, if you just talk about something and don't write anything down, generally nothing happens. Nothing changes. So generally, I think the whole point of these protected activities is actually to improve care. And I think we are less likely to do that if we're not writing anything down and we're just having a discussion. I don't think that's likely necessarily to have good long-term outcomes.
And I think that's clear from the regime and the annual reporting requirements, which is centred around, what have you discovered and what are you doing to address it? That it is a focus of it is to improve and change and do things better. It's probably also worth just observing that this very comprehensive privacy that you can obtain by jumping through the hoops to set up a protected quality assurance activity, it's not 100%. There are circumstances, probably reasonably rare, but nonetheless circumstances where that veil of secrecy can be pierced. And for example, probably the key way that can happen is that the Minister of Health can essentially direct, for a certain limited number of purposes, that the secrecy of that activity be removed. So, for example, if access to that information is needed for the purposes of investigating and prosecuting a criminal offence, would be one reason the minister might remove the secrecy. Another would be for the purposes of a royal commission or a commission of inquiry. So imagine if there was God forbid, another sort of national women's inquiry, and they wanted to look at a protected activity that was relevant to this sort of unconsented research that had happened. No doubt the minister in a circumstance like that would permit that to occur. But we're talking about pretty rare and extraordinary sort of circumstances.
But what you are saying, though, is that it wouldn't be a good idea in a mortality morbidity meeting to confess to having killed the patient, because that information could become available.
Indeed. So if you were planning on saying something radical, like you were administering analgesics not to address pain, but to shorten the patient's life because you thought that they'd suffered enough, then that's probably not something you should be banking on staying private for all time. If a colleague were to report that to the police and subsequently it were investigated and the police wanted the minute of what you had said as evidence in a trial, then I expect the police would go to the minister and ask for permission to go and get around the secrecy because of the context of prosecuting an offence.
And although it doesn't happen often, I did actually have a case many years ago where the minister got involved in obtaining information from protected activity like this. So
Because of a criminal offence?
can't remember the details. Sorry. It's only just come to mind.
So it does,
But it does happen.
Yeah, and but generally it does seem like that having an activity protected does provide quite good protection from disclosure and does allow clinicians to freely discuss adverse outcomes without worrying that their musings are going to be used against them by the HDC or the Medical Council. So how common is it for these to be in place, Sam?
I'm not sure I can answer that question, to be honest, because often we ask our members whether particular meetings or documents are protected, and often clinicians don't actually know. And I guess it's quite likely or possible that if it was a protected meeting, that it may have lapsed, and a lot of people may not be aware that it's lapsed.
Yeah, and I think if the named person resigns, you've only got a month to get another person named, and those details to the Minister of Health before the whole thing lapses. And if you don't do your report once a year, the whole thing lapses, and it only lasts 5 years anyway. So every 5 years you've got to renew it. So there are lots of opportunities for it not to be there. And as you say, so many doctors just don't know whether they are, So should we be encouraging clinicians to talk to their hospitals and their organisations and check what's in place, whether their activities do need to be protected?
Or alternatively, do you say, well, actually, this is a bit silly having these protected kind of discussions, and it's better for everything to be completely transparent, and therefore we don't need to worry about the activity at all. But I think we've already discussed the reasons why there are benefits in having a forum whereby people can openly discuss stuff without it being readily available. So,
yeah, I think that we clinicians tend to find it very difficult to admit to mistakes, to want to talk about it openly, and to not have any protection makes it even harder. And I think that, the learnings that could take place just won't happen. So I think it's a great thing to have these protected activities.
Yeah, I think it would be, even subconsciously, if you have the confidence of knowing you're in a safe space, the quality of the discussion that occurs may be richer. And it could be in subtle ways or ways that it's hard to point your finger at and saying, we wouldn't have had that discussion but for being in this protected environment. But I think it does have the potential to be a real benefit. And I think in hospitals or organisations, it's worthwhile, finding the right person to talk to, whether that's the hospital lawyers or what have you, to say, look, I'm chairing this. I want to know what the situation is. Have we applied for this? Is it still current and valid? I want to be able to be accurate and honest with the attendees about whether or not this is a protected activity or not.
I had a situation some years ago where I had a complaint received for a consultation that I did at the after hours, and fortunately, we had a GP peer review meeting very shortly after that, and I became aware that there had been an adverse outcome that had occurred, and I wanted to discuss it and genuinely ask, well, where did I go wrong? Did I stuff up? What could I have done better? But I think I would have been hesitant about bringing it up if it hadn't been an environment where both I felt confident in the people who were there, but also that it wasn't going to be disseminated widely as a result of that discussion. So,
And I think one of the other situations here is actually for reflections that you might do for CPD or your CME, your continued education with the colleges, that, when you're writing a reflection on a case that might not have gone so well, and providing that to the college or to some other educational forum, whether that's protected, because I think traditionally the colleges have applied for, and there are definitely some colleges that still have protected quality assurance activities to cover some of that educational content and reflection. And yet I'm pretty sure that some of the colleges recently have let that lapse, and they've just advised their members to anonymise those cases. But then the question is, if, does anonymising them make them protected? I don't know, Adam, if I was, writing a reflection on a college website or in my CPD file, is it protected?
Not if the college has just made a decision to no longer maintain that as a protected activity. So it's anonymised. It might be just at a practical level hard for a regulator to know that you've done it, that it exists. They might not know to ask for it, because of that, it might be quite an uncommon thing to end up being revealed or brought forward as part of an investigation. But it's not protected, and if they do find out that it exists and ask to see it, they will find a way to.
So anonymising it doesn't make it safe?
Not necessarily, because, in a really extreme example, and look, to be honest, I've never seen the HDC be this aggressive or thorough in terms of their investigation. They tend to be focused very much, appropriately on the contemporaneous records and giving the doctor the opportunity to provide their account now of how they look back and saw how things happened. But, maybe if this were going through to a prosecution by the Director of Proceedings or something like that, there was a suspicion that this existed, you could get the HDC just asking the college for all of your reflections, if you're not prepared to identify it yourself, and they'll figure out which one is clearly the index case. And that's, like I've said, I've never heard of that happening. It's a bit theoretical, but it's not impossible. I think it's a really sound thing for colleges to do, to continue to maintain these as protected, because they're going to get better quality engagement, I would have thought, from their members if they can go into CME and write reflections knowing that it is genuinely secret.
Okay, so look, I think it's about time to wrap this up now, and hopefully we've raised some awareness anyway about the fact that your hospital or organisation can apply to have quality activities protected. Maybe you'll go away from this podcast and ask if this has been set up in your hospital for certain activities, and if not, why not? If you get blank faces back, you may wish to get them to look at a very good resource that's published in September 2024 called Guidelines on Protected Quality Assurance Activities under the Health Practitioners Competence Assurance Act 2003, that's a mouthful, which is the Ministry of Health website, and it lays out how to set up and how to maintain protection on activities which you might be involved in. So thank you for listening to this podcast. I hope it's been helpful. We look forward to catching up with you in our next podcast. If you like Medical Protection podcasts, please subscribe and leave a review. If you would like a podcast on a specific topic, please email us on nzpodcasts@medicalprotection.org. So thank you, Tim. Thank you, Adam. Thank you, Sam, for coming along today. It's been interesting.
Thanks, Lucy.
Thanks, Lucy.